also doesn't say if you're convicted of subsection C. I mean, I think that's the problem for your argument. It says in the course of a violation of subsection C. And so I don't understand why the government believes in this case that it's entitled to the penalty structure that comes with section C if a person is convicted of C, when J doesn't say, and it could easily have said, any person who's convicted of subsection C, et cetera.
So, Your Honor, I think it is certainly true that Congress could have been clearer in this provision. My point was simply that it also doesn't say what petitioner is suggesting. We think the best reading of the statute is that C provides the basic elements of the offense. It provides the basic sentences, and then J sort of comes in to say, and when there's a death, we're going to add these other penalties. And I think that's consistent, as I was saying in my introduction, with how C5 works. I think it necessarily has to work that way. And so we think there's nothing wrong with sort of taking these provisions as they come, walking through C before you get to J.
So what do you do with the fact that J was actually enacted at a different time than C? And so that suggests to me that Congress was careful and thoughtful about the placement of J. They could have put it in C to accomplish what you've talked about, but they didn't. And J has its own penalty provision, not specifically cross-referenced in any way to C's penalty provisions. So I guess it just sort of seems to me that the enactment history also undermines the government's view that J is supposed to be ordering some sort of aggregation of the C penalties.
Certainly. So we actually think that the history is quite helpful for us, and if I could just explain why. I think there are three really key dates here. The first is that in 1968, Congress enacted this provision C without any concurrent consecutive requirement. A couple of years later, it adds the consecutive sentences bar. And then in 1994, as Your Honor noted, Congress added subsection J. And I think what's really significant at that time is that when Congress did so and it cross-referenced subsection C as a whole, subsection C was much simpler than it is today. It involved only three paragraphs, paragraphs 1, 2, and 3. Paragraphs 2 and 3, as today, defined drug trafficking crime and crime of violence. Everyone agrees that those have to come in, that the cross-reference to C and J necessarily includes those. And then in paragraph C1, it included all of the substance of the offense. So it included the base offense elements, it included certain mandatory minima, for example, if a particular type of weapon was used, and it included the bar on consecutive sentences. And I think it's particularly unlikely in 1994, when Congress cross-referenced subsection C as a whole, that what it really meant to do was take subsection C2 and 3, and then particular words and phrases out of C1. I think when Congress said subsection C, it meant subsection C.
But of course, it doesn't say subsection C as a whole. It just says a violation of subsection C. I appreciate that you keep saying that every time you talk about subsection C as it's referenced in J, but that's not what it says.
It's correct that it says a violation of subsection C, but if you look at subsection
C, which you can commit without reference to subsection C's cumulative penalties or any penalty, any of the mandatory minimums or anything like that, right? I mean, it's not the government's position that you wouldn't have a violation of subsection C without, the penalty structure.
I think that's correct, Your Honor, but I think it's also not true that Congress was sort of focusing on those elements in particular. I think another point that was discussed earlier with respect to what Congress was doing in this provision was, the focus on the death penalty. And while I think that is obviously something Congress was concerned with when it added subsection J, it's clear that Congress also knew, as Justice Kavanaugh was pointing out earlier, that term of years sentences would continue to apply for J violations. That's in the language of J1, of course. And we think that it's just completely implausible that at the time that Congress was enacting this statute, it meant to keep a mandatory minimum consecutive sentence, as this court explained in Abbott, Congress explained 3 times over that it's so important that individuals who engage in that base offense conduct receive that mandatory minimum consecutive sentence, but at the same time eliminated that when the person actually takes the gun out and kills someone.